afternoon, everybody. I'm really excited to introduce you to our speakers today for this session, which is addressing housing discrimination against people with disabilities. One of our speakers, her name is Helen Hardiman. She's an Assistant Attorney General and Policy Advisor in the Office of Civil Rights, where she investigates and litigates claims of discrimination against Virginians. Helen advises the Virginia Real Estate Board and Virginia Fair Housing Board as members of these bodies determine whether housing discrimination has occurred in individual cases. She also advises the Attorney General on civil rights issues and legislation. Helen practices law through a social work lens, striving to achieve social justice for undervalued communities. Prior to her state government work, Helen founded Hardiman Law PLLC to prevent and end housing discrimination in Virginia. In less than 2 years of private practice, Helen assisted over 100 families in securing and maintaining fair housing, including obtaining monetary relief for survivors of race, gender, disability, and family status discrimination, avoiding evictions, reinstatement of housing subsidies, and granting of reasonable accommodations. She also developed a robust training course for housing providers who demonstrate a commitment to preventing discrimination. And we also have with us today Regina Chaney. She's the Community Engagement and Outreach Specialist for Housing Opportunities Made Equal of Virginia. She's been with Home of Virginia for 34 years, and she favors her current position over that of all others because it allows her to engage and communicate with communities throughout the state, sharing information about the services provided by Home, educating and empowering families about their housing rights, informing communities about housing policies and programs, all of which she hopes will work towards achieving the organization's mission, which is to ensure equal access to housing for all. I'll now turn it over to Helen and Regina.
Thanks so much, Becca. Hi, friends. I'm Helen Hardiman. I use she, her pronouns. I am a 40-year-old white woman with shoulder-length blonde hair, and I'm wearing a bright pink blazer today. I'm at home, but my background is a shot of the Barbara Johns building where the Office of the Attorney General is housed. It's a beautiful building, and the words equality, justice, and opportunity are on the walls. So one thing Becca left out of my bio is that I'm the president of the Regina Chaney fan club. And it is truly an honor to be presenting with Regina. We're colleagues and friends from way back, and I just admire her work so much. So Regina and I are covering housing discrimination against folks with disabilities today. And that is a big area, but our plan for our time today is that I'm going to give you a quick overview of the laws that prohibit housing discrimination against people with disabilities. Regina is going to tell you about Home's role in this movement and how they can help folks who feel like they've been discriminated against. I'm going to talk briefly about how the state investigates and litigates these cases. And then if we have time, Regina and I would love to share with you some of the actual cases that we've worked on, because as y'all know, disability it's an individual thing. No two cases are alike. And so sometimes when you're talking about the laws, it helps to actually have examples from which to draw. So Regina, you ready to go? I mean, I'm gonna go first. I just wanna make sure you're ready.
Yes, I am.
Okay, let's do it. Okay, so I have to give a quick disclaimer that nothing I say should be attributed to the Attorney General, and I can't give you legal advice, but I will talk about fair housing to anyone who will listen. And housing discrimination against people with disabilities is extra important because 61 million adults in the US are currently living with a disability. Now, the last time I gave this presentation a couple of years ago, it was 50 million, it was 1 in 5. Now it's 1 in 4 of us. So if considered together, those of us with disabilities are the largest minority in the United States. And guess what? We need places to live. We deserve safe, affordable, accessible places to live in the communities of our choice. And so the legislature in Virginia, even before the federal legislature did so, actually added disability to the list of protected classes in the Virginia Fair Housing Law. That was in 1984. The Virginia General Assembly said you cannot discriminate based on someone's disability. The federal government, Congress, added disability to the list of protected classes in 1988. And I want to read to you some of the quotes that were offered on the floor as justifications for adding this protected class, just to kind of set the scene today. So Congress said, this is in 1988, individuals with disabilities have been denied housing because of misperceptions, ignorance, and outright prejudice, and that including this new protected class was a clear pronouncement of a national commitment to end the unnecessary exclusion of people with disabilities from the American mainstream. The right to be free from housing discrimination is considered essential to the goal of independent living. Therefore, Congress says, this law repudiates the use of stereotypes and ignorance and mandates that persons with disabilities be considered as individuals. Generalized perceptions about disabilities and unfounded speculations about threats to safety are specifically rejected as grounds to justify exclusion. That to me is really powerful. So as we start to talk about, sort of the black letter of the law and what elements you have to prove to show your case, really thinking about how Congress described the need for this and what animates this law really helps me remember how important these protections are. So disability, you probably also know this, but disability is the most frequent basis for allegations of housing discrimination in the country. Depending on what forum is counting allegations of discrimination, housing discrimination, it's anywhere from 50 to 60% of the number of allegations and complaints that come in are from folks alleging discrimination based on disability. It is a really big, important protected class. And part of the reason for that is, while disability is treated just like every other protected class, such that it's illegal to discriminate against someone based on disability, just like it's illegal to refuse to rent to someone based on race, or to impose discriminatory terms and conditions based on gender. Disability enjoys that equal status, but it actually is special in that there are 3 extra protections in the fair housing laws for people with disabilities that don't apply to the other protected classes. And in those protections, landlords and housing providers, in addition to just refraining from discriminating, they have to take affirmative steps to help people with disabilities fully use and enjoy their housing. And those 3 extra protections are reasonable modifications, reasonable accommodations, and physical accessibility requirements, or design and construction requirements. And that's what we're really going to focus in on at the top of this presentation. So before we talk about the protections, I just want to quickly define disability for you. Fortunately, in the fair housing laws, the definition of disability is really broad. It's a physical or mental impairment that substantially limits one or more major life activities, a record of such impairment being regarded as having such an impairment. That tracks the ADA definition of disability. The fair housing laws explicitly extend protections from discrimination based on disability to people residing with folks with disabilities or associated with people with disabilities. So it's broad in definition and broad in who it covers, including some non-disabled folks. Now, what it doesn't include, by statutory language, is folks that would constitute a direct threat to the health and safety of other individuals, or whose tenancy would result in substantial physical damage to the property of others. It also does not include current illegal use of or addiction to a controlled substance as defined by Virginia or federal law. And that creates some issues, but generally the definition of disability is going to be really, really broad. So let's talk about those extra protections that are afforded to people with disabilities. For reasonable modifications and reasonable accommodations, this is the basic principle. If someone has a disability, they request a modification or an accommodation, and I'll talk about the differences between those. Their request for the accommodation or modification is related to their disability and is necessary for their full use and enjoyment of the housing. And it's reasonable, which means not just the general reasonable man kind of standard. Reasonable means a specific thing in this context. If those things are true, the housing provider has to grant the request. That's the basic premise. Now there's a lot of legalese in there that, you know, opens the door for lawyers to argue about what those various terms mean, but that's the basic premise. If you have a disability and a disability related need and you ask for an accommodation or modification and it's reasonable, the housing provider has to grant it for you. Now let's talk about what reasonable modifications are. Those are changes to physical structures in the unit or in the common areas that are necessary for a person with a disability to use and enjoy the housing. These are things like ramps, grab bars, moving environmental controls down or up, installation of carpeting or acoustic tile to reduce noise, removal of carpet to facilitate wheelchair use, widen doorways, again, physical changes in the environment. And when we're talking about reasonable modifications in private housing, so non-subsidized, non-government housing, just the regular old private housing market, the person making the request, the person with the disability, does have to pay for reasonable modifications. The housing provider can ask for a few things to assure that the reasonable modification is legal. If there are building permits that need to be pulled, the housing provider can ask for that. They can ask for a plan or a sketch. They can ask that any construction be done in a workmanlike manner. But what the housing provider cannot demand as a condition of granting a reasonable modification request, and I see this a lot, they can't insist on a certain contractor. They can't insist on a certain type of aesthetic unless they want to pay for the difference to get there. They can't insist that you sign a liability waiver. They can't insist that you get insurance on the reasonable modification. All of those types of things are illegal conditions on the reasonable modification. A couple other things about reasonable modifications that are often misunderstood. A housing provider can require someone with a disability to restore the modification back to the original state only if it's internal to the unit. So if there's a ramp that gets put, say, to the leasing office or to the outside of the building, that the housing provider cannot require that be taken off when the person with the disability moves out. But if it's inside the unit, they can, and only if that modification is going to disturb the next resident's use of the property. So the example that I think of is if I have to widen a door to be able to get through it, that's probably good for the next person too. I'm not going to have to be required to narrow the door. But if I have to lower the kitchen counters pretty significantly, that's something that the housing provider could reasonably require me to restore when I move out. So that's reasonable modifications. What I see more commonly are reasonable accommodations. And these are not changes in the physical structure, but they're changes in exceptions, adjustments in policies, rules, practices, procedures, services, right? It's more intangible changes that a person with a disability needs to fully use and enjoy their housing. Reasonable accommodations have to be granted so that someone with a disability can enjoy not only their housing, but all of the common use areas as well. There are no limitations on the number of reasonable accommodations that someone is entitled to. As I've alluded to before, disability is a very specific, personal, individual thing. And I might need one reasonable accommodation for 10 years at a property. I might need one every month. It really depends on what my disability and my disability related needs are, but there's no cap. It also, my right to request a reasonable accommodation or be granted a reasonable accommodation, this survives throughout my whole tenure at a housing complex. So while I'm looking at the unit, while I'm applying, while I'm getting leased up, while I'm there, while you're evicting me from there, right? There's no specific time frame that the RA applies. It's the whole housing transaction. And some common reasonable accommodation requests, even though there really are infinite numbers, are parking, either widened parking, reserved parking, parking near certain amenities, extra spaces for caregivers. Assistance animals is a big one, and I explicitly use the term assistance animal to include service animals, emotional support animals, companion animals. All of those animals are considered assistance animals under fair housing laws. Transfers to different units or assistance in the application process. So really, again, there are infinite numbers of reasonable accommodations. There's no existing list of all of them. And then the final protection that just applies in fair housing laws to folks with disabilities are physical accessibility requirements. And this is really important because the Federal Fair Housing Act, the addition of disability, was in 1988. That predates the ADA. And my understanding is the ADA is powerful and it covers a lot of different contexts and areas of life that those of us with disabilities need to access. But when we're really talking about private housing, it's the fair housing laws that set the physical accessibility standards. And this is the more technical part of the fair housing law, but just to summarize, multifamily housing, so apartment buildings with 4 or more units built after 1991 have to include 7 very basic accessibility features. And this is not meant to be quote unquote fully accessible or ADA accessible. It's meant to have basic features that folks with disabilities can adapt if they need to. And that includes accessible public and common use areas, right? Can I get to the gym? Can I get to the leasing office? Are the doors wide enough for me to get through? That's the second one, and that's into the unit and areas outside of the unit. The third feature is the fair housing law requires accessible route into the unit and throughout the unit. So if there's stairs up into the unit, that's a problem. If there's stairs within the unit, that can be a problem as well. The fourth is light switches, electrical outlets, thermostats, and environmental controls being within a certain reach range. Reinforcement in the bathroom walls to allow the future installation of grab bars. So the fair housing laws don't require the presence of grab bars, but reinforcements behind the wall in case you do need to install them. Usable kitchens and usable bathrooms. And these protections, basically who can violate these protections are anyone involved in the design and the construction of the building. So these are the cases you see that DOJ brings against, like the architect, the developers, and the builders of new multifamily housing that are still creating inaccessible units. I mean, since this has been on the books since '88, it's applied since 1991. I'm still shocked and horrified at how many violations I see of these protections. But when you're talking about physical accessibility in apartments, you're not talking about ADA. In the private market, you're talking about fair housing. So I think that's an often overlooked and underutilized section of the law. So Regina, I will turn it over to you to talk about home and your role.
All right, thank you, Helen. Hello to everyone. It's a great afternoon. I'm glad to be here. And I am also excited to share this stage with Helen Hardiman. My name is Regina Chaney. My pronouns are she, hers. I am a seasoned African-American female with dreads. Today I'm wearing a canary yellow dress. I am at home. My background is the beautiful scenery of downtown Richmond. And it also displays Home's 50th year logo, so which we're all excited about. So I want to start off by just talking a little bit about Home. For those of you who are not familiar with Home, we're a private nonprofit organization. We've been around, like I said, for 50 years. 2021 is our birthday or our anniversary. Our overall mission is to ensure equal access to housing for all people. And we do that by assisting victims of housing discrimination. We have a housing counseling and education program, which provides down payment and closing cost assistance for first-time home buyers. The overall goal there with that assistance, counseling and education is to build generational wealth. We also have counselors who provide foreclosure prevention to help people save their homes, of course, from foreclosure. We have counselors who provide services through our Move to Opportunity program. That's a program where we assist families who have housing choice vouchers find housing in low poverty areas. And the goal there is to deconcentrate poverty. We also have our housing stability services. Those housing stability services include direct payments, housing, education and counseling and financial coaching. for families who are facing eviction. We also participate in the Virginia Rental Relief Program, which actually our role is statewide with that particular one. And of course, we have our research and policy team, where we research systemic and historic discrimination. And that team also leads state and local policy efforts. We want to make a note that a lot of our services are statewide. Some of them are based on restricted to certain localities, but we, any housing issue or concern or need, we ask that you call us, and if we cannot help you, we put you in the right direction. So with regards to fair housing, HOME actually receives funds for housing enforcement and education. And our process there with for someone who is interested or has a need for our services or support, we do intake, we advocate, we investigate, we litigate, we work with a legal team, and we educate. With regards to intake, we take calls from individuals who are concerned about some housing experience that they've had, that they have concerns about. And I will say right now that oftentimes, I don't think we hear from enough people because people are reluctant sometimes to give us a call to talk about what they've experienced. Sometimes that's out of fear for retaliation, which is also something that we can assist with, of course, if you file a complaint. But just not sure if what happened is against the law. And that's okay. What we want people to do, if there is some discomfort in what someone has experienced, we prefer that you call us and talk to us about it. Let us help you walk through, what happened and figure out the next step. We try to gather as much information as possible. I would say, when someone calls, as walking them through what happened, we gather the details. In our advocacy role, if needed, the fair housing staff, we assist in writing letters for reasonable accommodations and modifications, the protections that Helen just mentioned. We also will assist someone in preparing to file a fair housing complaint and actually help them through that process. Also providing resources to clients who have experienced a discriminatory or had a discriminatory experience. We also investigate claims of housing discrimination, and we do that often by using testers. Testing is a tool that's used to identify discriminatory practices or something that really didn't happen. Oftentimes, people are, like I said, really reluctant to come forward. I would say even with having an experience or feeling uncomfortable discussing that situation with us, it doesn't have to be the person who actually experienced it. It could be somebody calling for that person. It could be if the person who has experienced this discomfort, if you don't really want to move forward for whatever reason, that doesn't mean that HOME can't move forward with an investigation with regard to that particular housing provider or what has been experienced. And like I said, with the litigation piece, we seek and secure legal assistance in cases. And again, HOME may also be a co-complainant in a particular case. Educate, that's something that I do and I surely enjoy. And that's education and outreach to discuss the Fair Housing Act, the Fair Housing Law, describe what discrimination looks like. Because oftentimes people are not sure that they've been discriminated against. They have an uneasy feeling. And I will say feelings are very valid. And today, housing discrimination can be very, very subtle. It's done with a handshake and a smile. So oftentimes you don't even recognize it. So I would say if something sounds funny, sounds fishy, doesn't feel right, I encourage you to call or encourage whoever you know that's experiencing this discomfort to give home a call. We can, and I'll talk about, how to reach us. Of course, we have our phone number. Oh, I'm sorry, I didn't even share my screen. Let me see if I can do that right quick. Share. All right, these things I've gone over, but to reach out to us, you can just either call our telephone number, which is on this 804-354-0641, Virginia Relay 711. You can reach us on our website, which is homeofva.org, which I will let you guys know that it's an awesome website. It gives you a lot of information to help, we have a lot of information, all the services we provide and some of the things that we're doing. And if you have a need, if you can't call in or prefer not to, or just want to give us some basic information, you can certainly send us a message at help@homeofva.org. So right now, that's sort of my overview. I'm going to turn it back over to Helen, and we'll continue on. Thank you.
Thanks, Regina. So HOME, where I also used to work, as Regina so eloquently described, is a nonprofit fair housing agency. While they do get HUD funds to do fair housing work, they are decidedly an advocacy organization. So for folks who feel like they've been discriminated against, HOME is a great resource, like Regina talked about, for helping you figure out if you were discriminated against, and if you were, what your options are. In partnership with HOME, the Virginia Fair Housing Office, who is my client, right, at the Attorney General, I represent the state, and I specifically represent the Virginia Fair Housing Office and its 2 boards. And we are obviously a neutral government entity. And you can also, if you've gone to HOME or not, if you feel like you've been discriminated against, you can file a complaint of housing discrimination at the Virginia Fair Housing Office. And I've provided a link to do so with Sim and folks. Hopefully they can share. You can file a complaint. It's just a couple of pages for free with the Virginia Fair Housing Office within 1 year of the date in which you were discriminated against, or you believe you were discriminated against. And an incredible team of investigators at the Virginia Fair Housing Office will investigate your case. And that includes, at a minimum, interviewing you and interviewing the respondents, or the person, people, or entities that you claim have discriminated against you. Investigations almost always also include document review. So investigators will get documents from all of the parties. Sometimes there are witness interviews that need to happen. Sometimes there are on-site inspections and interviews that need to happen. But depending on the case, these investigators will gather all the relevant facts, and then they will put everything together in a report that they submit to either the Fair Housing Board or the Real Estate Board. And these are made up of Virginians who are appointed by the governor. They're volunteers. And those boards read over those big old reports and decide whether there is reasonable cause to believe that you were in fact discriminated against. And they vote, and they take a vote. And if they do think that there's reasonable cause to believe you were discriminated against, they tell me, their lawyer, to file a lawsuit in court, in state court, to seek relief on your behalf. So I still represent the Commonwealth, whose interest is obviously to remedy and to prevent any further discrimination. But the law also requires me to seek relief on behalf of the aggrieved person, the complainant, the person who feels like they've been discriminated against. And I have to maintain those lawsuits in state court. Now you'll notice I say if the board finds reasonable cause to believe you're discriminated against, the board cannot then order the respondents to do anything, to pay you, to implement policies. The board doesn't have that power. A court has that power, which is why we then have to take the case to court, sort of a 2-stage process. Now, all along the way, from basically a couple weeks after you file until all the way up till we get a jury verdict, you can be conciliating or settling or negotiating the cases. And there's a different team at the state of mediators who will, again, for free, try to help you resolve your fair housing complaint early in the game. And a lot of cases do, fortunately, resolve through mediation. And I think those are especially helpful in cases where folks are alleging disability discrimination, because that sort of quick, I mean, y'all know lawsuits can last for years and years. The ability to resolve something quickly with your landlord and get your reasonable accommodation or get your lease termination, your modification, whatever it may be, that's often a really helpful way to get things done early. So you do not have to go to home or the Virginia Fair Housing Office. You can also file a housing discrimination complaint with the U.S. Department of Housing and Urban Development. The Virginia Fair Housing Office has a work share agreement with HUD. So it's likely that if you file a complaint at HUD, they will refer it to the Virginia Fair Housing Office for investigation, but someone will investigate it if it meets certain jurisdictional elements. But you don't even have to go to HUD. You can also go straight to court within 2 years of when you allege you were discriminated against. This is not like in the employment discrimination context where you have to exhaust your administrative remedies by going to the EEOC before you go to court. The Virginia Fair Housing Law and the Federal Fair Housing Act say you have all of these options and you can choose which one is best for you. The point is just not to miss your deadlines. So I wanted to share a few what I would consider best practices for specifically reasonable accommodations, because that's the most common claim of disability discrimination in housing that I see. And again, I can't emphasize enough, every case is different. So I cannot give you a perfect recipe for your particular issue, but I can give you some best practices. First, let me say that what reasonable means in terms of a reasonable accommodation and modification. Again, it doesn't just mean like what Joe Schmo thinks is reasonable. Reasonable means it is not an undue financial and administrative burden on the housing provider. And there are various factors that go into assessing that. And that it's not a fundamental alteration of a housing provider's operations. If those two things are false, then your request is reasonable. So here are some examples that HUD gives to try to clarify what undue financial burden might mean or not mean. And they say a tenant with a mental illness requesting their landlord to call them daily to confirm they're not hospitalized is probably an undue financial and administrative burden. But having a landlord call the same tenant 2 days prior to the date their rent is due to remind them to pay the rent probably is not an undue financial burden. That would be more reasonable. And it depends on the housing provider and it depends on the person with a disability. Again, you have to analyze all these different factors. So what's a fundamental alteration such that it would render a reasonable accommodation request unreasonable? HUD says, asking a landlord to send someone to read all mail to a blind tenant, right, US mail, probably is a fundamental alteration, unless they otherwise provide those kinds of services. But asking a landlord to read only notices from the landlord to the blind tenant, probably not a fundamental alteration. That's probably going to be a reasonable request. So even if you have a disability-related need, you've made a request for an RA or an RM, an accommodation or a modification, and the landlord or housing provider is saying it's unreasonable because it fits into these undue hardship categories, basically. That does not give them the automatic right to deny your request right then. They have to, by Virginia law, and this is a code section that we got put into the law explicitly in 2017, they have to engage you in the interactive process. So the landlord has to receive your request, analyze your request. If they think it's unreasonable, they have an affirmative duty to come to you and say, we think your request is unreasonable. Here are some alternative accommodations that we would like to explore. And that is supposed to be a solution-focused back and forth process where basically you try to get to a solution that works for everyone. Now, a person with a disability does not have to accept a landlord's proposed alternative accommodation. If it will not meet their disability needs, then that's a no. And if their original request is reasonable, the landlord has to grant it. But there's this process that's meant to basically try to compromise and negotiate something that's going to work for everyone else. So here are some best practices. if you're requesting a reasonable accommodation or modification. Make sure you participate in the interactive process. I've seen several folks with otherwise good claims lose because they basically, sometimes the interactive process is like a tennis match. And if the landlord hits the ball into your court and it's on you to hit it back, right, to say that alternative accommodation is not going to work for me, or I will take it, you know, technically you've sort of left the match, you've left the process, and that unfortunately can extinguish your claim. It's a best practice to put everything in writing. The law doesn't require you to do that, but I'm telling you, it's the best and sometimes only way to prove your case, when you made the request and what you said and what they said back to you. Be specific in your reasonable accommodation and modification request. You do not have to give the landlord your medical records or your full life history, but to the extent you can be as clear and as detailed as necessary to justify, to verify your disability and to justify your disability related need for what you're asking for, and be really specific about what you're asking for, that's going to put the burden on the landlord to either grant it or engage in the interactive process. Because sometimes when folks are vague about their requests, these cases get sort of lost in the tennis match and it becomes unclear kind of who's at fault. So Regina and I have seen great RA letters. We've seen great doctor verification letters and medical verification letters, and we've seen really, really bad letters. The law is pretty clear about what's sufficient, but it always helps to be, you know, above that line. So don't have a letter that says, my medical diagnosis requires me to have an animal in my unit. Say, I am a person with, so medical diagnosis doesn't mean you're a person with a disability, right? I am a person with a disability as defined by fair housing laws. My disability related need is to have this specific dog in my unit because this specific dog does these things to ameliorate the symptoms of my disability. So I've now verified my disability. I've been specific about my disability related need. And then I'm going to say, please, what am I requesting? Waiver of pet fees, you know, a transfer to a different unit, or whatever. Be specific about what you're requesting. And if I don't hear back from you by X date, I will assume you denied my request. It's also really helpful to put that deadline in that letter. And then you have to give the landlord a reasonable amount of time to respond to that. What's reasonable depends on the particular housing provider. But they don't have to say no in order to violate your rights. They can just basically blow you off or delay for long enough that also violates your rights. So it's important to kind of keep track of all the time that's passed. And then if you're being injured in the interim while they're considering your request or after they deny your request, track those injuries, track those damages, because ultimately that's what you're going to be asking for them to pay you to compensate for the discrimination in the future. So those are some of my best practices for requesting RAs or RMs. Looking at the time, Regina, it looks like we are going to have time to talk about our cases. Do you want to launch into some of your favorites?
Well, I did want to sort of add some examples of some cases that we've seen at home. And I think you mentioned earlier that disability complaints far exceed all other complaints that we have. What we see a lot of certainly is for service animals, ESAs. Not sure what goes on with housing providers, not allowing families to keep their ESAs or have them, charging the pet fees, which an assistant animal service ESA is not a pet. And that is something that we try to get housing providers to understand. So there are no pet fees. There are no pet issues because it's not a pet. So we've seen a lot of those cases. What we've also seen lately are parking issues. I know you mentioned that, Helen, and that is providing a designated parking space for a person with a disability to be either near their unit or closer to the unit than they had been. We had one case that, you know, it's amazing to me how people think sometimes. And this housing provider, this is a housing management, property management firm, and someone requested designated parking closer to their unit and asked for handicap, you know, designation. And, you know, this housing provider just went through all sorts of craziness to the point that they actually blocked off a whole row of parking spaces that could not be used by anybody, and in retaliation to this. I mean, you know, so that's some of the stuff that goes on that people really need to share with us. Another thing I used to see when I was on the fair housing team, but I hadn't heard that is still happening, but I know it does. And that is for folks who have their benefits. You have your benefits coming either the 1st or the 3rd. The old age 1st and 3rd of the month for Social Security or SSI or disability or whatever you have is long gone. I mean, you can receive your benefits any time of the month, but there are still providers that will, of course, charge a late fee if you pay after your due date. Well, rather than rack up a bunch of fees, this is a reasonable accommodation request. I would like to move my due date, my rental payment due date, from the 1st of the month to the 20th of the month. Say you receive your benefits at the 15th of the month or the 16th. Make it close to the time when you're receiving those benefits. And that will take, you know, take care of those fees that you don't have to pay. It's unbelievable how many people have had the fees that added up so that they then became behind with their rent because of that ongoing charge. So that's something I think that people don't think of. With regards to parking, changing of the due date, the ESA denials, I can't think of any others right now, Helen, if you can come up with a few. I know you and I have worked on a couple that were amazing cases. That's all I can say about it.
And they're also unique, right? There really are no two alike. I mean, even if we're talking about someone who needs pet fees waived for their assistant's dog, like even those can be different based on who's in the household and where the housing is. And no two are unique. And I love these cases. And I really love, when I was in private practice, helping folks with disabilities understand these rights and then see them play out so that they can secure their housing. So I can talk about a few of my cases. I have 6 current lawsuits pending in state court, and 2 of those allege housing discrimination based on disability. In one case, it's a family of 4, 2 children. The 2 children and the mom have various disabilities, but they had requested some designated parking for what I thought was pretty clear disability related need, that a condo association basically gave them the runaround on, so that they were going to do it, never did it. We allege, the state alleges that amounted to an illegal denial of a request for a reasonable accommodation. There were some issues in the same community with having transportation to schools, carrying kids with disabilities were going to be disallowed from coming into the community. That I felt was a disability related housing discrimination issue. The mom basically went on the news to air those grievances, which led to what we allege was harassment by a board member of the HOA. He allegedly basically called and threatened to rescind a bunch of their other reasonable accommodations. So that is pending in court. And then the other disability related case that I'm litigating is an assistance animal was denied in a family's application process to move into a single family home, specifically because that assistance animal was a pit bull, and the landlord, the owner, and the property manager of the home claim that if they were to allow the pit bull on the property, that it would have caused them to either lose their insurance, their liability insurance, or have to pay more for their insurance. And our position, based on longstanding federal law, but actually codified Virginia fair housing law, again in 2017, and some of those links are in the chat. Sim posted those for me, thank you. Our position is the cost of your insurance is one factor in determining whether a reasonable accommodation request poses an undue financial burden, but it's not the only factor. There are other factors that need to be considered and weighed in making the determination. So now we will have a judge weighing all of the factors and making that determination. Also at the Attorney General's office, I've settled 2 other disability related cases. One was in Southwest Virginia. The landlord evicted a family over the presence of their assistance animal. And then another one was not a reasonable accommodation case. It was just a straight up landlord evicting a tenant with disabilities that he knew about because the tenant had disclosed to the landlord when she was looking at the place that she had disabilities. She didn't have any need for a reasonable accommodation, but he perceived her to basically have issues because of her disabilities. And she had some interesting interactions with him that left her a little uncomfortable, not because of her disability, just because she felt like he wasn't listening and he was demeaning her. She asked for someone to be present during their interactions. He perceived that to be a reasonable accommodation request, which we found it wasn't, but he ended up terminating her lease by saying, quote, "We don't feel you are a good fit for our property. We want you to be happy and feel that you need a place and a landlord that can accommodate your special needs." So that settled, as you can imagine, pretty quickly, because that's pretty good evidence of discrimination. There's one other case that I'm working that's not quite at litigation yet, but it's a design and construction case where a relatively large townhome condo complex in Hampton Roads, I believe we're probably going to find has been designed and constructed out of compliance with the physical accessibility requirements. Also had the chance to write an amicus brief in a case in Northern Virginia. Some neighbors were suing the operator of a group home for adolescent girls with anxiety, depression, and comorbid substance use disorders. I think this is all too common across Virginia, but the group home had a private lawyer who was arguing that they had a right, to be there. The county was going to let them be there, but the neighbors were saying the county basically needs to kick them out or impose extra restrictions on them. And the Attorney General on behalf of the state filed a friend of the court brief saying this house qualifies as under the disability protections of both the state zoning laws and the state fair housing laws, because it was less than 8 people with disabilities living together. And so the law says you have to just treat them like a single family. You can't make them do extra things or pay extra amounts. And then just quickly, before I started at the Attorney General's office, I had my own private practice, and I had a handful of really interesting cases that alleged disability discrimination. I had one of my very favorite clients who was a longstanding tenant at an apartment complex here in Richmond. It was taken over by a new property management company. They reran criminal histories on everyone. And then she got this notice, sorry, you failed our criminal background check, you have to get out. And she looked at the criminal record and she had a very minor conviction for something a long time ago that she explained was directly related to her disability. And so we wrote her a reasonable accommodation letter and said, hey, you shouldn't hold this against her because it was because of her disability. And by the way, she's been a good tenant for years and years and years. So this isn't even really a good, basis on which to evict her. And she got to stay. That was awesome. Another woman I helped keep her housing. She had been non-renewed by her landlord. So she wasn't being evicted. Her lease wasn't being renewed. And that housing was really important to her because of not only the physical layout of the property and the unit, she had some mobility issues, but it was also really close to a lot of her medical providers and her support network. And so we wrote a reasonable accommodation letter that said, you know, she has a disability related need to basically live here for longer, and they granted that and she got to stay. I've done early lease terminations as reasonable accommodations for people with PTSD needing to get out of a particular unit because they witnessed something so horrific therein and were basically being triggered by staying there. For a client with autism who has educated me on meltdowns for folks with autism that she was having and was putting her in basically a dangerous situation. She needed to leave the unit. People with various multiple chemical sensitivities and other sort of autoimmune issues needing to get out of units that have mold and other issues. I had a client who developed postpartum depression and needed to move out of her unit and back in with her mother. I've asked for transfers to different parts of the complex. I've done reasonable accommodation requests and modification requests for playground equipment and a fence for children with autism to be able to fully use and enjoy their housing and get the treatment they need. And then I've had several cases dealing with so-called, and I'm doing air quotes, noise. I had a deaf client that had several assistive devices that her neighbors claimed were disturbing them. We got those waived or accommodated. I've had a couple of families with children who have autism and who caused some loud disturbances. Those are able, landlords can find ways to accommodate those things, right? I know the solution sometimes seems like it's going to be hard or impossible, but again, in that interactive process, the landlord needs to do everything they can that's reasonable to accommodate someone with disability so they can stay housed. So I've had the pleasure of working on a lot of those different cases and meeting a lot of wonderful people who I was proud to work alongside as they enforced their fair housing rights.
Helen, I did want to add, I'm glad you brought up the criminal history piece, because I do want to let folk know that although having a criminal history is not a protected class, those cases meaning people who have been denied housing, that they believe it was because of their criminal history, Home would like to hear about those. We have been successful in the past and working with families who have been denied housing because of their criminal history, and had a great outcome. So we've had some success with that and invite people to come over, to bring those issues to us. I remember one case I remember also with regards to flooring, like if a person needs their flooring changed from rug or carpet to hardwood floors because they're now either in a wheelchair because they now use a rollator. I remember working on a case forever with that. Those are the type of cases that, we want to hear about. Also, I remember a positive outcome for the client that I had who was hard of hearing, and changing the system in the apartment to notify her in case of a fire, changing the alarm to a flashing light. And that took a little while, unbelievably, but it was actually granted. So, it's all in the enjoyment of that person's unit. That is why these accommodations are important. And people should feel okay to come forward with your needs, to ask for help when you feel like you're not being heard. And that's part of what Home is here for too, as your advocate. If you feel like you're not being heard, if you think that, I'm not comfortable here, I really can't live here, and don't feel like you have to move or make, a lot of adjustments to your housing and ignore your particular needs for somebody else who doesn't understand the law or don't want to either work with you and be reasonable about providing housing for you, because that is a basic need for everybody. We all need it. So anyway, that's my little spill on that.
Well, and Regina, I think that the added benefit to getting your own need met is in a lot of these cases, and I know the state insists on this and home does as well, they result in these housing providers adopting better policies, getting trained on these laws. And so often bringing these to their attention. I mean, some of the bad landlords are just, you know, hopeless, but a lot of housing providers don't necessarily know their obligations. And so when this is brought to their attention, it can sometimes generate actually improvements for everyone who's going to live here forever. So they'll implement reasonable accommodation policies where they're advertising to their applicants or tenants, hey, if you need a reasonable accommodation, this is how you apply for it. And this is the process that we're going to use to assess it. So it could actually be, you know, good for everyone to have the courage to really stand up for these rights.
And I will say that I thank you, Helen, because I know when you were at home and even after you left, you have come up with some great ideas on helping those housing providers with new policies. So thank you for what you've done, particularly with criminal history.
I love you more. So Becca, I think we're probably to the Q&A portion. If you want to hop on. Hello again.
Sure. Great. Sounds good. This was incredibly informative. I really appreciate the hard work from both of you. And I think it was really interesting as well. We have one question that just came through on the chat. There's a question about retaliation. Often clients worry about asking for help due to retaliation. How do you address this concern with your clients? If you're aware of the retaliation occurring, how do you address that?
Regina, you want to take this or you want me to go? Okay, I can start. This is a legitimate, reasonable fear because it does happen. And what I talked about before about keeping everything in writing and keeping good records can help you avoid retaliation, right? Because now you have the email or the letter that was mailed certified that said, I need this reasonable accommodation request. It's dated. And then if the landlord retaliates against you, you're going to be able to show, based on the amount of time that passed, that they took that adverse action, whatever it is, against you because you requested this reasonable accommodation request. And even if someone finds out later that you weren't entitled to that reasonable accommodation, or the landlord granted the reasonable accommodation and you lose the RA claim, the underlying claim, the retaliation claim can still stand. So winning the retaliation claim for someone who's alleging retaliation is not based on whether they win the other types of discrimination claims. It's really about keeping good records. And for retaliation, the timing really matters, because courts look at the time between the protected activity, right, asking for the accommodation, and the adverse action to prove causation. So if everything is dated and you've got a really short time period there, a month or less, then a fact finder is probably going to infer that the landlord took that adverse action in retaliation for you. It's terrible to think that you might be retaliated against, and it does happen. But as soon as it does happen, if it does, you can file a complaint. Or if you already have a pending complaint, say you've already filed a complaint saying that they refused to grant my reasonable accommodation and then they retaliate against you, you can amend your complaint to add the retaliation claim.
Absolutely. We've had that happen before. I worked on a case out in Southwest Virginia a couple of years ago, and the housing provider was retaliating against the tenant. And in fact, one day as I was speaking to her on the phone about things that were happening, I could hear the property manager at the door banging, and actually worked with that client to address the issue. I just asked her to open the door and to put me on speakerphone and, you know, kind of help to de-escalate that situation. So I know it is a scary thing, but it's also, you know, to advocate for yourself or have somebody else to help to advocate on your behalf. We don't want people to be taken advantage of. And that's why that's there too, because the retaliation is real, intimidation is real. That people, you know, be open and honest and just let us know as an advocate what's going on, because nobody needs to live like that. Nobody needs to live in fear.
You can also, just as a bonus, sorry, Becca, add to your reasonable accommodation request, your letter, if I don't hear back from you by X date, I will assume you denied it. Please also note under this code section, it's illegal to retaliate against me for asking for this accommodation. Just a nice little hint to them that you're, on notice that retaliation is also illegal.
Absolutely.
Great.
The more information you can give them, the better. Makes them think twice.
Very good. Very good. Thank you both. I actually have a follow-up question, I guess. If your retaliation claim is legally successful, what types of damages are you entitled to?
That's a great question. And I meant to address this when I was talking about going to court. So if you've gone through the administrative process or not, and you get to court, the remedies under the fair housing laws are vast. They are, in my opinion, some of the most broad in favor of the plaintiff or the person being discriminated against civil rights laws in the country. So you can get actual damages, which includes not just your out-of-pocket costs, like your application fee if you get denied, but also your lost housing opportunity. If you want to rent in building A and you get denied or steered because of your disability or other protected class and you end up in housing B, well, maybe B is further away from your family, your church, where you get your hair done. I mean, all of that is compensable if you can prove that you were discriminated against, and that's why you ended up in housing unit B. Actual damages also include emotional distress, and that varies based on the person, but that can be significant. I mean, being discriminated against is not a small thing. That can leave you really traumatized. And so emotional distress damages are compensable in fair housing cases. You can also get, without limitation, punitive damages in fair housing cases. In most other contexts, those are limited to $350,000 under Virginia law, but there's no cap on them. Under the fair housing law, you can get, if the state brings a case, the state can ask for civil penalties to be paid, and those are increasing depending on the number of prior violations of law. You can get attorney's fees, which is unfortunately often a very scary thing for landlords to think that maybe they won't have to pay a lot of damages, but they'll have to pay the other side's attorney's fees. And then perhaps most powerfully, you can get all sorts of injunctive relief. So you can get a court to tell the landlord to do a bunch of things or to stop doing a bunch of things. And the sky is really the limit there, as long as the thing that needs to be done is to prevent, further discrimination. So these are things like implementing policies, which is really important, going to training, but there are also things like firing a property manager or a maintenance person, or, significant actions that landlords will have to take in order to remedy and prevent future discrimination. So really powerful remedies in these laws.
Great, thank you.
I just wanted to say some of the cases that I remember working on, particularly with ESAs, they ranged anywhere as far as settlements from $5,000 to $90,000. So, yeah.
Wow, thank you both very much. I appreciate it. I was also thinking, I know, Helen, when you started talking about the law, I had a question about the law. We talked about housing that was built after 1991. Is there any protections that are given for housing that was built before 1991? Or if the housing undergoes some type of modification, is there any protections that are involved there?
Yeah, so the fair housing law only requires those 7 basic physical accessibility requirements for housing built for occupancy after March of 1991.
Okay.
So anything before that, you would still have a right to request a reasonable modification if you need something physically changed, but that's going to put the cost burden on the tenant or the resident, the person with the disability who needs the change. If a covered dwelling, and again, we're talking about multifamily units, right? So this doesn't apply to single family homes, doesn't apply to townhouses, but other buildings with 4 or more units. It will apply to basically new portions of those complexes, but not unless it's almost, they just leave the walls up kind of modification. It's not going to apply to other types of rehab. It's really for new multifamily construction. Now, there are cases that, you know, DOJ has won where you can tell that a developer is leaving some very small portion of a building intact to try to say that it's, you know, it's historic or it's not covered under various different laws. And HUD and DOJ and courts have found, no, that's basically new housing. It has to be constructed in compliance with these requirements. And again, there are other accessibility laws. I mean, the building code incorporates these requirements. So theoretically, if they're meeting building code, that they're meeting these fair housing requirements. I know ADA in certain circumstances imposes additional accessibility requirements. So I'm just talking about private residential housing after 1991.
Great, thank you. I would encourage, if anybody who is listening in here wants to ask any questions, you can add them to the chat. I was also, and this came to mind for me because I live in a development downtown where there's really limited parking available. And so the only parking that's available on site has to be paid for by the resident. If an individual needed an accessible parking spot in that situation, would they still be required to pay for that spot if they needed to?
My understanding of that is yes. I'll let Regina chime in if she has a different impression. But accommodations are not for finances, they're really for the disability. I mean, it would depend on the circumstances, of course, but so another example that I think is more about money than disability is, say I need to move into a different unit, but the only unit that's available to meet my needs it costs more.
Right.
I think, you know, under most circumstances, it would be fair for the landlord to charge me that extra expense. I can imagine a case where that wouldn't be, but you know, these laws don't accommodate your pocketbook, they accommodate your disability, so to speak.
Regina, did you have anything that you may want to add, or have you ever had a situation like that?
No, only where someone paid for a parking space and asked that the space itself be noted as handicap. They wanted the handicap logo
Right.
on that in that space so that other people, you know, wouldn't accidentally or park there without having, you know, a disability stickers or what have you. And they were asked to pay for it. And that was not something that they had to pay for to put the handicap logo there, but they still had to pay for the space.
All right. Well, thank you, Regina. Anybody have any questions they want to ask our two wonderful guests today? That would be great.
I do want to make a comment about the modifications, that if the housing has any subsidy there, that modifications are not paid for by the tenant. They are then paid for by the housing provider. I didn't know if you said that, Helen, before.
I hadn't, thank you, yes.
I guess one of the things that I did want to reiterate when talking to folk about calling in and to talk about this situation, those who are sort of skeptical about filing a complaint, it is just as important that you call to share your experience with, say, home, to talk about it, because then again, we can, if you don't want to file a complaint, that's still an investigation that we can partake in, right? So Rebecca doesn't want to talk about, I want to tell you what happened, but I don't want to file a complaint. Okay, but you give us enough details that we can investigate, and then we can file potentially our own complaint that in the long run may benefit Rebecca. You see what I'm saying? So
Sure.
So don't hesitate discussing the situation because you feel like if I talk about it, then I'll have to file a complaint. No, you talk about it because it's happened. And, you know, we would hope that you would, you know, follow through, but if not, then it's still something that we can look into, and it's not just swept under the rug. and the issue, because I hear people used to say all the time, you know, I don't know what can be done for me, but I just don't want this to happen to anybody else, right? And we don't either. So that's why just giving us the details, you know, what happened. And if you want to just kind of walk away from it, that's okay. We'll just let us, you know, work on that issue and address it.
Well, that's excellent work that you all do. Thank you so much.
Because if you don't, you can't change something that you certainly don't know about, but you can't, you know, change anything that you just look at and go, it's nothing that can be done. It's always something that can be done.
Well, I thank both of you very much for your time today and all of the informative information you gave us. I can tell that you both are very passionate about this, which is really important. And we are so lucky to have two such passionate advocates with us today. If anybody has any remaining questions, they can add them to the chat.
Becca, I just wanted to say thanks for having us.
Of course.
And Regina, always a pleasure.
Echo. And if I could put my email in the chat, if anybody wants to just, you know, reach out to me just to talk about a situation that they are concerned about. I'm always, you know, open to hear from folks. So I'm going to put it in there right now.
Thank you for that.
So Becca, one of my favorite things about Regina is she has a very unique way of closing meetings, which I think looks like we're going that way. So if she could bless us out of here, I would love to hear her phrase.
Absolutely. I suggest that everyone go forth and be productive.
That's fantastic. I hope that we all do as well. Well, we look forward to seeing everybody in the sessions for the rest of the day, and look forward to everybody being productive. So thank you both ladies for your time, and take care of yourselves.
All right. Goodbye, guys.
See y'all.